Labor law. Topic: Adjudication process. Reference power of government. Under which section of the Industrial Disputes Act 1947 can the government refer industrial disputes to adjudication? Answer option A, section 10. The reference power of the government in industrial disputes is exercised by option B, the appropriate government, state or central. The government's reference power under the Industrial Disputes Act is considered as option A, discretionary and not obligatory. The government may refuse to refer a dispute for adjudication if option B, the dispute is not an industrial dispute under the Act. Under Section 10 of the Industrial Disputes Act 1947, the government can refer industrial disputes to option C, both A and B. The government's reference power ensures that industrial disputes are option C, resolved by impartial adjudicating bodies. The government reference power under Section 10 is used when option A, there is a failure in conciliation. Which of the following can the government refer under its reference power for adjudication? Option A, disputes regarding wages, bonus, retrenchment. Who determines whether a dispute can be referred for adjudication? Option C, appropriate government, state or central. What is the typical time limit for the government to make a reference for adjudication under the Industrial Disputes Act? Option D, no time limit. The power of the government to refer disputes is outlined in which schedule of the Industrial Disputes Act? Option B, second schedule. The government can refer a dispute to adjudication at any time before the commencement of option C, a strike. A dispute can be referred to adjudication if it relates to non-payment of wages and compensation. In the absence of a trade union, the government can still refer an industrial dispute to adjudication based on option C, an individual worker's application. The power of reference is primarily exercised by the government in order to option C, ensure fair resolution of disputes without unnecessary delay. If the government refuses to make a reference under Section 10, the aggrieved party may answer option C, seek judicial review in the High Court. The industrial dispute that deals with workers' compensation would be referred by the government to option C, both labor courts and industrial tribunals. The power to refer industrial disputes is vested in the government to option C, ensure disputes are resolved in accordance with law. An example of a dispute that can be referred by the government for adjudication is option C, a dispute regarding the bonus structure. Under the Industrial Relations Code 2020, the reference power of the government has been Option D. Further strengthened for quicker resolution. Which of the following is not an essential requirement for the government to refer a dispute for adjudication? Option C. The dispute must involve a collective bargaining agreement. Which type of dispute would be referred to an industrial tribunal for adjudication? Option B. A dispute regarding work hours or wages. Which of the following authorities can refer a dispute to adjudication in India? Option C. The Labour Commissioner. If a dispute is referred to the government for adjudication, it is mandatory that option D. The matter is heard and decided by a labor court or tribunal. What happens if the government refuses to refer a dispute to adjudication? Option B. The affected party can approach the labor court for a decision.